Greg Woods received his Doctor of Jurisprudence from San Francisco Law School and holds a Bachelor of Arts from San Jose State University. At San Francisco Law School, Greg was a recipient of the Bernard Whitkin Award for Academic Excellence in Contracts Writing and was an editorial staff member with the San Francisco Law Review. He served as a certified legal intern with the Office of the District Attorney in San Francisco. Greg Woods presently serves as lecturer with the Department of Criminal Justice Studies at San Francisco State University and was recently named Lecturer of Justice Studies at San Jose State University and at the Department of Criminology Studies at Sonoma State University. As an educator, constitutional scholar, law enforcement legal trend watcher, and student of history, Greg constantly seeks and receives information from a wide variety of sources and is in the forefront as a commentator on topical issues in criminal law. Outside the classroom, Greg has been acknowledged by former students at the annual San Francisco State Scholar-Athlete Reception as a faculty member who made a valuable impact on their academic lives. Greg Woods may be reached via LinkedIn or by email at woods.greg@gmail.com.
Welcome to the Center for Continuing Education. I'm Greg Woods, and we will be discussing ethical issues of contemporary criminal justice. Ethical Issues of Contemporary Criminal Justice explores standards of professional responsibility specific to the legal representation, law enforcement, and corrections in the United States. Attorneys will define and apply concepts in the analysis of law and policy through an increased awareness of the model rules and codes of conduct. Throughout our conversation today, we will be analyzing both the issues that are specific to the urgent need for doing the right thing in the criminal justice system in the United States today. Further, with the baby boomer generation reaching old age and ages of retirement, we have a new young fleet of attorneys ready to step in and take their place. Unfortunately, the new attorneys will not have the benefit of the wisdom of what some of the more seasoned attorneys will share with them as far as their own experiences dealing with the criminal justice system, specifically their relationships with law enforcement, the courts, and corrections. And so what we're going to do today is we will be spending the balance of our time cross-referencing those standards of conduct specific to the American Bar Association, the ABA. Also, the rules specific to the California Bar Association. Because with these two sets of rules of professional responsibility, we can best understand the jurisdictions throughout the United States as we understand the necessity for doing the right thing. In his work, A Brief History of Legal Ethics, Louis Parley reminds us that prior to the turn of the last century, there were basically no ethical codes that could be identified as the basis for the regulation of lawyers' conduct. The ethics of the profession were, up until then, based either on innate perceptions of what constituted ethical professional conduct, or were drawn from other areas of the law relevant to lawyers, such as the fiduciary obligations existing in the law of agency. Our own traditional notions of ethics are implied from the word itself, from the Greek ethos, meaning loosely the study of morals or character. We must remember morals are distinct from ethics in that morals are an internal compass of personal principles and individual notions of right and wrong. Ethics are recognized rules of conduct of a particular class, group, or culture. Moreover, when morals transcend culture, time, and space, ethics are guidelines for acceptable behavior within a particular time and space. The time and space that we are dealing with now is the year 2015, the beginning of the 21st century, where we are faced with urgent issues that require the most ethical of conduct by those people who are charged with the duty of preserving civil rights and maintaining public safety. To that end, we will be discussing peace and coactivity through relationships based upon trust, and that trust between the attorney and the client, the attorney and the law enforcement officer, the attorney and the court, the attorney and the corrections officer, in preserving those very rights for the client and working for peace and coactivity and nurturing relationships through integrity. Integrity is based upon character and competence. Character is what you do when no one is around. Competence is doing the right thing based upon training. To that end, we will be discussing ways through which to make those decisions to be both competent and also exercise discretion with character. Because we are dealing with issues in today's criminal justice world, which oftentimes take the headlines in the form of officer-involved shootings. We are dealing with ethical issues specific to body cameras and surveillance, drone surveillance, terrorism. We also are experiencing hyper-incarceration rates in our nation. All of this means that we need to have a prescribed access to justice. We need to increase our access to justice. And the way that we do that is through our law and our authority from the courts and the government, the policies and procedures based upon the trust of the people. Add the character component, and what we have are men and women of integrity of the legal profession. To preserve the integrity of our legal system, the laws must be written and enforced to ultimately reflect the ethical demands of the community and should be designed to solve those problems we face collectively. It's because of the duties and discretion the occupation demands that the study and ongoing understanding of ethics is crucial to maintaining the culture of the legal profession. Although other groups have been granted powers of self-government, the legal profession is unique because of the close relationship attorneys have on the processes of government, law enforcement, and the criminal justice system as a whole. This connection is realized daily in that ultimate authority over legal profession and how it is vested largely in the courts. In 1887, what is believed to be the first code of legal ethics appeared in Alabama. The code has been identified as resting on an 1854 essay by George Sherwood and formed the basis for several other state codes. The American Bar Association, formed in 1878 and adopted the Canons of Professional Ethics in 1908. The model rules of professional conduct were adopted by the ABA House of Delegates in 1983 and serve as models for the ethics rules of most states. California is the only state that does not have professional conduct rules that follow the format of the ABA model rules. The California rules of professional conduct are intended to regulate professional conduct of members of the state bar through discipline. They have been adopted by the Board of Trustees and approved by the California Supreme Court pursuant to statute to protect the public and to promote respect and confidence in the legal profession. The relative autonomy of the legal profession carries with it special responsibilities of self-government and self-policing. The profession has a responsibility to assure that its regulations are conceived in the public interest and not in furtherance of a parochial or self-interested concern. Every lawyer is responsible for observance of the rules of professional conduct. A lawyer should also aid in securing their observance by other lawyers. Neglect of these responsibilities compromises the independence of the profession and public interest which it serves. It is unlike any other group, save emergency room physicians. Attorneys are in the greatest position to impact the lives of others through their work in the criminal justice system. Whether they serve as defense counsel or prosecution, be they judge of the superior or justice of the Supreme Court, it is by their authority vested from the people they have the privilege to apply statutes, admit and respond to evidence, and seek convictions, acquittals, and appeals in this never-ending struggle for the access to justice. A lawyer, as a member of the legal profession, is a representative of clients, an officer of the legal system, and a public citizen having special responsibility for the very quality of justice that we enjoy. Ask anyone who has been arrested if they are awake. Among their most common demand will be for one's attorney. Alone with the assistance of their counsel, whether paid for privately or provided by the people, the accused stares down criminal charges with hope to cast doubt on the prosecutor's assertion or negotiate a reasonable plea agreement. As a representative of clients, a lawyer performs various functions. As advisor, a lawyer provides a client with an informed understanding of the client's legal rights and obligations and explains their practical implications. As advocate, a lawyer zealously asserts the client's position under the rules of the adversary system. As negotiator, a lawyer seeks a result advantageous to the client but consistent with requirements of honest dealings with others. As an evaluator, a lawyer acts by examining a client's legal affairs and reporting them to the client or to others. A lawyer, as a member of the legal profession, is a representative of clients, an officer of the legal system, and a public citizen having special responsibility for the quality of justice. Lawyers play a vital role in the preservation of our society. The fulfillment of this role requires an understanding by lawyers of their relationship to our legal system. The rules of professional conduct serve to define that relationship. That relationship has also been explained as a ship that can only move forward if it is filled with integrity. In other words, it is the integrity that keeps the keel watertight. It is the integrity of the profession that keeps that ship moving. Another way to look at it is if we think about character and competence, and we remember that integrity of the profession is going to be suspended wholly by the pillars of character and competence. And therefore, as an attorney, the duty is to continue to endeavor to be both competent and to act with character so that we can preserve the integrity of the system. Because integrity of the system welcomes access to justice. And lawyers are responsive to the needs of the community through their representation of their clients and as being officers of the courts. What is generally called ethics of the profession is but consensus of expert opinion as to necessity of professional standards. Also, the etiquette of the profession, which Wharton reportedly described as the code of honor agreed on by mutual understanding and tacitly accepted by members of the legal profession. Remember, when we're talking about the ethical standards, we're talking about decision-making. We're talking about integrity in times of crisis, because it is in those times of crisis that the public trust is going to be most valuable. Professional integrity, the law and the right to practice in the legal profession. Practicing is a right regulated by sources of authority, preventing unauthorized practice of law. We rely on competent investigation to avoid or solve all problems in a world where justice counts. Criminal law especially holds this to be true. Ongoing access to justice through competent investigation ensures a proper trial. An incompetent investigation and or improper trial will decrease one's access to justice. We need to understand the importance of the study of ongoing ethical relationships between the attorney and the client, the court, and the corrections system in our ongoing understanding of the criminal justice system. We must be able to define ethics and ethical issues and distinguish those ethics from morals. We need to understand the sources of those ethical codes and the history upon which the ethical codes have been created. Also, the culture and philosophical traditions, together with those political sources of ethical conduct. All in an understanding of integrity, which is defined as the quality of being honest and having strong moral principles, moral uprightness. Synonyms for integrity include honesty, honor, good character, to be principled, to be ethical, moral, righteous, to have virtue, to act with decency and fairness, to be sincere and truthful and trustworthy. And in this is the duty to the profession, to be competent. When we approach any ethical issue, the duty of the attorney is to maintain their competence, pursuant to Rule 1 of the Model Rules of Professional Conduct. Further, competence means to know what it is that you have to know. Further, it means to know what it is that you don't know so that you can know that you must learn about that thing that you don't understand. Lastly, if you know that you will not be able to understand and comprehend and deal with a specific issue with the kind of expertise that is required to be competent, you must associate with another member who does. So as we discuss these concepts, I want you to think about knowing what you know, knowing what you don't know, and therefore knowing what you must learn, and then lastly, knowing what is impossible to learn to be competent, and therefore associating yourself with someone who possesses that type of expertise. This is the color of the responsibilities identified in the Model Rules of Professional Conduct. A lawyer shall provide competent representation to a client. Competent representation requires legal knowledge, skill, thoroughness, and preparation that is reasonably necessary for the representation. The California Rules of Professional Conduct, Rule 3-110, discusses failing to act competently, where a member shall not intentionally, recklessly, or repeatedly fail to perform legal services with competence. For purposes of this rule, competence in any legal service shall mean to apply the diligence, learning, and skill, and mental, emotional, and physical ability reasonably necessary for the performance of such service. If a member does not have sufficient learning and skill when the legal service is undertaken, the member may nonetheless perform such services competently by associating with, or where appropriate, professionally consulting another lawyer, reasonably believed to be competent, or by acquiring sufficient learning and skill before performance is required. In an emergency, a lawyer may give advice or assistance in a matter in which the lawyer does not have the skill ordinarily required, where referral to or consultation with another lawyer would be impractical. Even in an emergency, however, assistance should be limited to that reasonably necessary in the circumstances. The Model Rules of Professional Conduct continue with an recitation of Rule 5-5, the unauthorized practice of law. A lawyer shall not practice law in a jurisdiction in violation of the regulation of the legal profession in that jurisdiction, or assist another in doing so. A lawyer who is not admitted to practice in this jurisdiction shall not, except as authorized by these rules or other law, establish an office or other systematic and continuous presence in this jurisdiction for the practice of law, or hold out to the public or otherwise represent that the lawyer is admitted to practice law in this jurisdiction. The California Rules of Professional Conduct continue with Rule 1-300, Unauthorized Practice. A member shall not aid any person or entity in the unauthorized practice of law. A member shall not practice law in a jurisdiction where to do so would be in violation of regulations of the profession in that jurisdiction. The model rules continue. Rule 5.7, Responsibilities regarding law-related services. A lawyer shall be subject to the rules of professional conduct with respect to the provision of law-related services. The term law-related services denotes services that may reasonably be performed in conjunction with and in substance are related to the provision of legal services and that are not prohibited as unauthorized of law when provided by a non-lawyer. The California Rules of Professional Conduct continue with Rule 1-100, Rules of Professional Conduct. The purpose and function. The following rules are intended to regulate professional conduct of members of the State Bar through discipline. They have been adopted by the Board of Governors of the State Bar of California and approved by the Supreme Court of California pursuant to the Business and Professions Code sections 6076 and 6077 to protect the public and to promote respect and confidence in the legal profession. These rules, together with any standards adopted by the Board of Governors pursuant to these rules, shall be binding upon all members of the State Bar. For a willful breach of any of these rules, the Board of Governors has power to discipline members as provided by law. So let's talk about the access to justice. The access to justice preserved in the Constitution gives access to those people who want to redress their grievances pursuant to the First Amendment. Further, the Fifth and the 14th Amendments provide rights to due process. We have substantive due process, the right to life, liberty, and property. We also have the right to procedural due process. Procedural due process means notice and a hearing. Neither notice nor hearing will be understandable to most people without the effective assistance of counsel. The right to counsel is triggered upon the accusation stage, the formal criminal charge, or also at a critical stage. And when we talk about the effective assistance of counsel, these rights from the Sixth Amendment made applicable to the states through the 14th Amendment trigger the standard of effect. And therefore, if we must preserve and sustain the access to justice, we have to understand the ethical implications associated with both effective and ineffective assistance of counsel. After all, on appeal for conviction, the number one litigated issue is the ineffective assistance of counsel. The access to justice is wholly dependent upon the preservation of the Sixth Amendment right to the effective assistance of counsel. And the court gives us guidance when it is that we distinguish the effective assistance from the ineffective assistance of trial counsel. The ineffective assistance of trial counsel is one of the most frequently raised claims in state and federal post-conviction petitions. Ineffective assistance of counsel is a claim raised by a convicted criminal defendant that their attorney's performance was so ineffective that it deprived them of the constitutional right guaranteed by the assistance of counsel clause of the Sixth Amendment to the United States Constitution. Hardly surprising, given reports of trial attorneys who refuse to investigate their cases before trial, never meet with their clients before the day of trial, and fail to file any motions or object to inadmissible evidence offered at trial. Unfortunately, the current structure of indigent defense funding makes it impossible for many public defenders to provide effective representation to their clients. The American Bar Association recently concluded that indigent defense in this country is in a state of crisis, and therefore to protect the fundamental right to a fair trial, the court has given us some seminal cases, specifically the case of Strickland versus Washington, and then most recently Padilla versus Kentucky, and also Missouri versus Fry. Strickland versus Washington from 1984. This was a decision by the Supreme Court of the United States that established the standard for determining when a criminal defendant's Sixth Amendment right to counsel is violated by that counsel's inadequate performance. In Strickland, the court has recognized that the right to counsel is the right to the effective assistance of counsel. Government violates the right to effective assistance when it interferes in certain ways with the ability of counsel to make independent decisions about how to conduct the defense. Counsel, however, can deprive a defendant of the right to effective assistance by failing to render adequate legal assistance. The ineffective assistance of counsel in criminal justice-related practice includes numerous collateral issues in regard to plea agreements. In Padilla versus Kentucky from 2010, Justice Stevens delivered the opinion of the court. A case in which the court decided that criminal defense attorneys must advise non-citizen clients about the deportation risks of a guilty plea. The case extended the Supreme Court's prior decisions on criminal defendants' right to counsel to immigration consequences. Justice Kennedy reiterated the significance and standards prescribed in Strickland and Padilla as he delivered the court's 2012 opinion in Missouri versus Fry. In the context of claimed ineffective assistance that led to the lapse of a prosecution offer of a plea bargain, a proposal that offered terms more lenient than the terms of the guilty plea entered later. This court now holds that, as a general rule, defense counsel has the duty to communicate formal offers from the prosecution to accept a plea on terms and conditions that may be favorable to the accused. The American Bar Association recommends defense counsel promptly communicate and explain to the defendant all plea offers made by the prosecuting attorney. ABA Standards for Criminal Justice Pleas of Guilty from 1999. And this standard has been adopted by numerous state and federal courts over the last 30 years. From the model rules of professional conduct, we have meritorious claims and contentions from Rule 3.1. A lawyer shall not bring or defend a proceeding or assert or controvert an issue therein, unless there is a basis in law and fact for doing so that is not frivolous, which includes a good faith argument for an extension, modification, or reversal of existing law. A lawyer for the defendant in a criminal proceeding or the respondent in a proceeding that could result in incarceration may nevertheless so defend the proceeding as to require that every element of the case be established. This is important when we think about character, morality, the etiquette, the critical thinking that must be taking place while we approach each individual set of issues. Further, we have to be mindful of the fact that when the attorney opens him or herself up to practice, they need to partner with others, and they do so by reaching out. And so if we are mindful of the ways through which these communications are had, we have to limit those communications to the constraints of the California Rules of Professional Conduct. Rule 1-120, assisting, soliciting, or inducing violations. A member shall not knowingly assist in, solicit, or induce any violation of these rules or the State Bar Act. What we're talking about here are rules involving moral turpitude. Moral turpitude. Exactly what is moral turpitude, and how do we define crime associated with moral turpitude? It has been defined from the 1930 case Marsh versus State Bar of California. Conduct contrary to justice, honesty, modesty, or good morals. From Kirby versus Alcoholic Beverage Control of 1969, we have another gradation in our understanding of moral turpitude, where it be any crime where fraud is an underlying element will constitute a crime involving moral turpitude. The California Court of Appeal in People versus Chavez from 2000 states, the California Supreme Court has divided crimes of moral turpitude into two groups. The first group includes crimes in which dishonesty is an element, for example, fraud, perjury. The second group includes crimes that indicate a general readiness to do evil. Crimes in the latter group are acts of baseness, vileness, or depravity in the private and social duties which a man owes to his fellow man or to society in general. We can also look at Black's Law Dictionary for a traditional understanding of moral turpitude, containing many of the same terms that the court uses in an act of baseness, vileness, or depravity in the private and social duties which a person owes to his and other, or to society in general, contrary to the accepted and customary rule of right and duty between people. It's the policy of the State Bar of California that persons who have been convicted of violent felonies, felonies involving moral turpitude, and crimes involving a breach of fiduciary duty are presumed not to be of good moral character in the absence of a pardon or a showing of overwhelming reform and rehabilitation. In this sense, the character test has been failed. Failed because there has been a lack of adherence to the very structure of what contains the notions of right and wrong. To do the right thing and to conduct oneself appropriately pursuant to the standards of the profession. So when we talk about misconduct, what we're discussing fairness, candor, trustworthiness, observance of fiduciary responsibility, respect for and obedience to the law, and respect for the rights of others, the judicial process. Involvement in activity that constitutes an act of misconduct or an act of moral turpitude does not necessarily preclude an applicant from admission to practice law in California, or from a member to continue to practice law in California. However, an applicant who has committed such acts must demonstrate rehabilitation prior to receiving a positive moral character determination. An act of misconduct may include, but is not limited to, behavior that results in a criminal conviction, behavior that results in a sustained accusation of fraud, or a sustained allegation of unauthorized practice of law. The violation of a school's honor code that involves moral turpitude or results in expulsion, professional discipline, and license revocation or disbarment. Material omissions from the moral character application, misstatements in the moral character application, failure to provide requested information, and misrepresentations during informal conferences conducted by the committee are also considered to be significant misconduct. So as we have seen through our case analysis of Strickland, Padilla, and Fry, we have collateral issues that are significant to our ongoing professional responsibility. as it pertains to competence. Competence in the communication and competence in the understanding of plea negotiations. Because when we're discussing immigration issues, the very real threat of deportation looms over those issues. When we're talking about issues of professional conduct, we're talking about disciplining, which could then ultimately result with disbarment and a lack of livelihood. Lastly, when we're discussing notions of misconduct and ideas of honesty, we have to understand how those notions touch and concern those people who will help to perfect the representation for the client. Whether those be family members who may very well become responsible for a portion through consent of legal fees, or also through law enforcement officers that will have to give testimony based upon their own understanding of whether or not there was probable cause to place somebody into some state of custody. Criminal justice related issues could arise from law enforcement, courts, corrections, and as a result, there is no group better situated than the lawyer to self-police and to perform reform solutions for those very ethical problems that we face. The Model Rules of Professional Conduct, Rule 8.3, is specific to reporting professional misconduct. A lawyer who knows that another lawyer has committed a violation of the rules of professional conduct that raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects shall inform the appropriate professional authority. A lawyer who knows that a judge has committed a violation of applicable rules of judicial conduct that raises a substantial question as to the judge's fitness for office shall inform the appropriate authority. This rule does not require disclosure of information otherwise protected by Rule 1.6 or information gained by a lawyer or judge while participating in an approved lawyer's assistance program. The model rules continue with Rule 3.3, candor toward the tribunal. Make a false statement of fact or law to a tribunal, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. Fail to disclose the tribunal legal authority in the controlling jurisdiction known to the lawyer to be directly adverse to the position of the client and not disclosed by opposing counsel, or offer evidence that the lawyer knows to be false. If a lawyer, the lawyer's client, or a witness called by the lawyer has offered material evidence and the lawyer comes to know of its falsity, the lawyer shall take responsible remedial measures, including, if necessary, disclosure to the tribunal. A lawyer may refuse to offer evidence other than the testimony of a defendant in a criminal matter that the lawyer reasonably believes is false. A lawyer who represents a client in an adjudicative proceeding and who knows that a person intends to engage, is engaging, or has engaged in criminal or fraudulent conduct relating to the proceeding shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. The duties stated above continue to the conclusion of the proceeding and apply even if the compliance requires disclosure of the information. In an ex parte proceeding, a lawyer shall inform the tribunal of all material facts known to the lawyer that will enable the tribunal to make an informed decision whether or not the facts are adverse. The California rules continue with Rule 3-200. Prohibited objectives of employment. A member shall not seek, accept, or continue employment if the member knows or should know that the objective of such employment is to bring an action conduct a defense, assert a position in litigation, or take an appeal without probable cause and for the purpose of harassing or maliciously injuring any person, or to present a claim or defense in litigation that is not warranted under existing law, unless it can be supported by a good faith argument for an extension, modification, or reversal of such existing law. In the nature of law practice, however, conflicting responsibilities are encountered. Virtually all difficult ethical problems arise from conflict between a lawyer's responsibilities to clients, to the legal system, and to the lawyer's own interest in remaining an ethical person while earning a satisfactory living. The rules of professional conduct often prescribe terms for resolving such conflicts. Within the framework of these rules, however, many different issues of professional discretion can arise. Such issues must be resolved through the exercise of sensitive professional and moral judgment, guided by the basic principles underlying the rules. These principles include the lawyer's obligation zealously to protect and pursue a client's legitimate interests within the bounds of the law, while maintaining a professional, courteous, and civil attitude toward all persons involved in the legal system. The model rules in Rule 5.5 discuss unauthorized practice of law, in that a lawyer shall not practice law in a jurisdiction in violation of the regulation of the legal profession in that jurisdiction, or assist another in doing so. A lawyer who is not admitted to practice in this jurisdiction shall not, except as authorized, establish an office or other systematic and continuous presence in the jurisdiction for the practice of law, or hold out to the public or otherwise represent that the lawyer is admitted to practice law in this jurisdiction. A lawyer admitted in another United States jurisdiction and not disbarred or suspended from practice in any other jurisdiction may provide legal services on a temporary basis in that jurisdiction that are undertaken in association with a lawyer who is admitted to practice in this jurisdiction and who actively participates in the matter, are in or reasonably related to a pending or potential proceeding before a tribunal in this or another jurisdiction. If the lawyer or a person the lawyer is assisting is authorized by law or order to appear in such proceeding or reasonably expects to be so authorized, are in or reasonably related to a pending or potential arbitration, mediation, or other alternative dispute resolution proceeding in this or another jurisdiction. If the services arise out of or are reasonably related to a lawyer's practice in a jurisdiction in which the lawyer is admitted to practice and are not services for which the forum requires pro hoc vice admission, or arise out of or are reasonably related to the lawyer's practice in a jurisdiction in which the lawyer is admitted to practice. A lawyer admitted in another United States jurisdiction and not disbarred or suspended from practice in any jurisdiction may provide legal services in this jurisdiction that are provided to the lawyer's employer or is its organizational affiliates and are not services for which the forum requires pro hoc vice admission, or are services that the lawyer is authorized to provide by federal law or other law of this jurisdiction. In California, Rule 1-300 states that the unauthorized practice of law is where a member shall not aid any person or entity in the unauthorized practice of law. A member shall not practice law in a jurisdiction where to do so would be in violation of regulations of the profession. So it is upon this foundation of character, whereby we have competence and integrity, to the profession, to the client, to the courts. Our competence is to know what we have to know to serve our clients and the courts and the community. If, however, we don't understand what is necessary to give representation to our client, we must learn what it is that we are deficient in. And if we conclude that we will not possess that level of expertise by the time that we need it, then we must associate ourselves with someone who does in fact possess that expertise, because we are advocating and representing the interests of our clients. The duty of those who practice in the criminal justice system, well, this includes the prosecution, who ultimately is acting through the public trust for the people. In any criminal court, it is the district attorney, the prosecutor, who appears on behalf of the people of that jurisdiction. The defense counsel is retained by the accused, and the defense counsel, pursuant to the regulations set forth in the professional rules together with the Constitution of the United States, require that the accused have assistance effective of counsel. Lastly, we have that serves the interests of the people and also the interests of the accused, while prescribing the appropriate sentence upon a reasonable understanding that the burden of proof beyond a reasonable doubt has been carried. The role of law and the bad business of crime, preventing harm and preserving civil rights, equal protection, and the 14th Amendment. Consensus conflict and pluralist paradigms in the understanding and perpetuation of narratives that are antithetical to the security and public safety that we expect. Further, we understand the unauthorized practice of law and also the duty to zealously represent pursuant to the Model Code of Professional Responsibility. The duty to the client. According to the model rules, Rule 1.2, the scope of representation and allocation of authority between client and lawyer. A lawyer shall abide by a client's decisions concerning the objectives of representation and, as required by Rule 1.4, shall consult with the client as to the means by which they are to be pursued. A lawyer may take such action on behalf of the client as is impliedly authorized to carry out the representation. In a criminal case, the lawyer shall abide by the client's decision, after consultation with the lawyer as to a plea to be entered, whether to waive jury trial, and whether the client will testify. A lawyer shall not counsel a client to engage or assist a client in conduct that the lawyer knows is criminal or fraudulent, but a lawyer may discuss the legal consequences of any proposed course of conduct with a client and may counsel or assist a client to make a good faith effort to determine the validity, scope, meaning, or application of the law. Zealous representation. According to the ABA, the lawyer's responsibilities are thus: as a representative of clients, a lawyer performs various functions. As advisor, a lawyer provides a client with an informed understanding of the client's legal rights and obligations and explains their practical implications. As advocate, a lawyer zealously asserts the client's position under the rules of the adversary system. As negotiator, a lawyer seeks a result advantageous to the client but consistent with requirements of honest dealings with others. As an evaluator, a lawyer acts by examining a client's legal affairs and reporting about them to the client or to others. A lawyer's responsibilities as a representative of clients, an officer of the legal system, and a public system are usually harmonious. Thus, when an opposing party is well represented, a lawyer can be a zealous advocate on behalf of a client and at the same time assume that justice is being done. So also, a lawyer can be sure that preserving client confidences ordinarily serves public interest because people are more likely to seek legal advice and thereby heed legal obligations when they know their communications will be private. Financial relationships with clients. Fees and contracts. Formation of relationship between client and lawyer, agreement and scope of representation, preserving the identity of the funds and property of a client, and then ultimately terminating the lawyer-client relationship. We have to look at due process in the Fifth and 14th Amendments to understand what is in fact owed to the client. We also have to consult ethical systems, and we can do that by taking a look at deontological versus teleological forms of ethics. In other words, do we do the right thing, or do we do the wrong thing with the hope of receiving the right result? The model rules proceed with a duty. In other words, if we look at the way through which we conduct ourselves, at settlement, our negotiations at trial, our negotiations with prospective clients in regard to fee, or other entities within the criminal justice system, we must have disclosure and open negotiations consistent with the duty to do the right thing throughout the process. In doing so, in preserving that duty, we will secure a just and righteous result. No more is a just and righteous result required than when we're dealing with incentive of profit and incentive of money. And therefore, the earliest form of money on the mind of the attorney is the fee for the client's services, the fee that will be rendered to the client with the hope of preserving the client's rights and remedies at trial. The model rules of professional conduct give us guidance with Rule 1.5 regarding fees. A lawyer shall not make an agreement for, charge, or collect an unreasonable fee or an unreasonable amount for expenses. The factors to be considered in determining the reasonableness of a fee include the following: the time and labor required, the novelty and difficulty of the questions involved, and the skill requisite to perform the legal service properly. The likelihood, if apparent to the client, that the acceptance of the particular employment will preclude other employment by the lawyer. The fee customarily charged in the locality for similar legal services. The amount involved and the results obtained. The time limitations imposed by the client or by the circumstances. The nature and length of the professional relationship with the client. The experience, reputation, and ability of the lawyer or lawyers performing the services, and whether the fee is fixed or contingent. The scope of the representation and the basis or right of the fee expenses for which the client will be responsible shall be communicated to the client, preferably in writing, before or within a reasonable time after commencing the representation, except when the lawyer will charge a regularly represented client on the same basis or rate. Any changes in the basis or rate of the fee or expenses shall also be communicated to the client. A fee may be contingent on the outcome of the matter for which the service is rendered, except in a matter in which the contingency is prohibited. A contingent fee agreement shall be in a signed writing by the client and shall state the method by which the fee is to be determined, including the percentage or percentages that shall accrue to the lawyer in the event of settlement, trial, or appeal. Litigation and other expenses to be deducted from the recovery, and whether such expenses are to be deducted before or after the contingent fee is calculated. The agreement must clearly notify the client of any expenses for which the client will be liable, whether or not the client is the prevailing party. Upon conclusion of a contingent fee matter, the lawyer shall provide the client with a written statement stating the outcome of the matter and, if there is a recovery, showing the remittance to the client and the method of its determination. A lawyer shall not enter into an agreement for, charge, or collect any fee in a domestic relations matter, the payment or amount of which is contingent upon securing of a divorce, or upon the amount of alimony or support or property settlement in lieu thereof, or a contingent fee for representing a defendant in a criminal case. A division of a fee between lawyers who are not in the same firm may be made only if the division is in proportion to the services performed by each lawyer or each lawyer assumes joint responsibility for the representation. The client agrees to the arrangement, including the share each lawyer will receive, and the agreement is confirmed in writing, and the total fee is reasonable. Fees are addressed by the California Rules of Professional Conduct in Rule 4-200. A member shall not enter into an agreement for, charge, or collect an illegal or unconscionable fee. Unconscionability of the fee shall be determined on the basis of all the facts and circumstances existing at the time the agreement is entered into, except where the parties contemplate that the fee will be affected by later events. Among the factors to be considered where appropriate in determining the conscionability of the fee are the following: the amount of the fee in proportion to the value of the services performed, the relative sophistication of the member and the client, the novelty and difficulty of the questions involved and the skill requisite to perform the legal service properly, the likelihood, if apparent to the client, that the acceptance of the particular employment will preclude other employment by the member, the amount involved and the results obtained, the time limitations imposed by the client or by the circumstances, the nature and length of the professionality and relationship with the client, the experience, reputation, and ability of the members or members performing the services, whether the fee is fixed or contingent, the time and labor required, the informed consent of the client to the fee. When we're talking about fees, typically we're talking about billable hours, unless, of course, we're talking about government employees who take the legal representation and ultimately charge the taxpayer. So for billable hours, we're talking about all sorts of creative ways through which someone might be able to afford legal expenses. Some attorneys negotiate their fee agreements through promissory note. And even if a prospective client does not have the funds to support the services that would be rendered by an attorney, most attorneys are willing to negotiate with the individual for a monthly payment plan tailored for their own fee negotiation and their own specific circumstance. Wage assignments are used, where a monthly sum is paid automatically, and the employer doesn't know the nature of the payment. This is particularly useful for defense attorneys who are negotiating pleas and who understand that their client might very well not be able to generate an income for the foreseeable future. Therefore, when they do have an income, that income will then have the monthly sum automatically removed through the wage assignment. The California Rules of Professional Conduct, specifically Rule 1-320, Financial Arrangements with Non-Lawyers, specifies neither a member nor a law firm shall directly or indirectly share legal fees with a person who is not a lawyer, except that an agreement between a member and a law firm, partner or associate, may provide for the payment of money after the member's death to the member's estate or to one or more specified persons over a reasonable period of time, or a member or law firm undertaking to complete unfinished legal business of a deceased member may pay to the estate of the deceased member or other person legally entitled thereto that proportion of the total compensation which fairly represents the services rendered by the deceased member. Or, a member or law firm may include non-member employees in a compensation, profit-sharing, or retirement plan, even though the plan is based in whole or in part on a profit-sharing arrangement, if such plan does not circumvent these rules or the Business and Professions Code. A member may be prescribed registration, referral, or participation fee to a lawyer referral service established, sponsored, and operated in accordance with the State Bar of California's minimum standards for a lawyer referral service in California. A member shall not compensate, give, or promise anything of value to any person or entity for the purpose of recommending or securing employment of the member or the member's law firm by a client, or as a reward for having made a recommendation resulting in employment of the member or the member's firm by a client. A member's offering of giving a gift or gratuity to any person or entity having made a recommendation resulting in the employment of the member or the member's law firm shall not of itself violate this rule, provided that the gift or gratuity was not offered or given in consideration of any promise, agreement, or understanding that such a gift or gratuity would be forthcoming, or that referrals would be made or encouraged in the future. A member shall not compensate, give, or promise anything of value to any representative of the press, radio, television, or other communication medium in anticipation of or in return for publicity of the member, the law firm, or any other member as such in a news item, but the incidental provision of food or beverage shall not of itself violate this rule. When we're discussing fees and those kinds of financial agreements that we can engage in with clients and other members of the public, we have to be mindful of the model rules, Rule 1.15, specific to safekeeping property. A lawyer shall hold property of clients or third persons that is in a lawyer's possession in connection with a representation separate from the lawyer's own property. Funds shall be kept in a separate account maintained in the state where the lawyer's office is situated or elsewhere with the consent of the client or third person. Other property shall be identified as such and appropriately safeguarded. Complete records of such accounts, funds, and other property shall be kept by the lawyer and shall be preserved for a period of 5 years after termination of the representation. A lawyer may deposit the lawyer's own funds in a client trust account for the sole purpose of paying bank service charges on that account, but only in an amount necessary for that purpose. A lawyer shall deposit into a client trust account legal fees and expenses that have been paid in advance, to be withdrawn by the lawyer only as fees are earned or expenses incurred. Upon receiving funds or other property in which a client or third person has an interest, a lawyer shall promptly notify the client or third person. Except as stated in this rule or otherwise permitted by law or by agreement with the client, a lawyer shall promptly deliver to the client or third person any funds or other property that the client or third person is entitled to receive, and, upon request by the client or third person, shall promptly render a full accounting regarding such property. When in the course of representation a lawyer is in possession of property in which 2 or more persons, one of whom may be the lawyer, claim interests, the property shall be kept separate by the lawyer. The dispute is resolved. The lawyer shall promptly distribute all portions of the property to which the interests are not in dispute. California rules continue with Rule 4-100 in preserving the identity of funds and property of a client. All funds received or held for the benefit of clients by a member or law firm, including advances for costs and expenses, shall be deposited in one or more identifiable bank accounts labeled trust account, client's funds account, or words of similar import, maintained in the state of California or with written consent of the client in any other jurisdiction where there is a substantial relationship between the client or the client's business and the other jurisdiction. No funds belonging to the member or the law firm shall be deposited therein or otherwise commingled except as follows. Funds reasonably sufficient to pay bank charges. In the case of funds belonging in part to a client and in part presently or potentially to the member of the law firm, the portion belonging to the member or law firm must be withdrawn at the earliest reasonable time after the member's interest in that portion becomes fixed. However, when the right of the member or law firm to receive a portion of trust funds is disputed by the client, the disputed portion shall not be withdrawn until the dispute is fully resolved. A member shall, Promptly notify a client of the receipt of the client's funds, securities, or other properties. Identify and label securities and properties of a client promptly upon receipt and place them in a safe deposit box or other place of safekeeping as soon as practicable. Maintain complete records of all funds, securities, and other properties of a client coming into the possession of the member or law firm and render appropriate accounts to the client regarding them. Preserve such records for a period of no less than 5 years after final appropriate distribution of such funds or properties, and comply with any other order for an audit of such records issued pursuant to the rules of procedure of the State Bar. Relationships with clients, confidential information of a client, the attorney-client privilege, the duty of confidentiality, and when confidences are waived. In defining and responding to criminal behavior, it's imperative to maintain the relationship with the client. And by maintaining the relationship with the client, we must give them the vehicle through which to communicate fully with complete disclosure. And the way to preserve the trust in such a relationship is through confidential communications. In the California Rules of Professional Conduct, Rule 3-100, confidential information of a client shall be dealt with accordingly. A member shall not reveal information protected from disclosure by the Business and Professions Code without the informed consent of the client. A member may, but is not required to, reveal confidential information relating to the representation of a client to the extent that the member reasonably believes the disclosure is necessary to prevent a criminal act, that the member reasonably believes is likely to result in the death of or substantial bodily harm to an individual. Before revealing confidential information to prevent a criminal act as provided in paragraph B, a member shall, if reasonable under the circumstances, make a good faith effort to persuade the client not to commit or to continue the criminal act, or to pursue a course of conduct that will prevent the threatened death or substantial bodily harm, or do both. Inform the client at an appropriate time of the member's ability or decision to reveal information as provided. In revealing confidential information, the member's disclosure may be no more than is necessary to prevent the criminal act, given the information known to the member at the time of the disclosure. Further, with this disclosure comes the duty of unimpaired loyalty and the avoidance of conflicts of interest. The conflict of interest might be readily apparent, it might not be readily apparent, and therefore we must proceed accordingly. Because those personal interests that may affect objectivity, those interests may be concurrent with representation or not, but concurrent representation of clients with conflicting interests is not tolerated, and the conflict between current and former clients must be understood before accepting the responsibility to loyalty, confidentiality, the duty of confidentiality. In California, this relates to a member's obligations under the California Business and Professions Code, which provides it as a duty to a member to maintain inviolate the confidence, and at every peril to himself or herself to preserve the secrets of his or her client. A member's duty to preserve the confidentiality of client information involves public policies of paramount importance. Preserving the confidentiality of client information contributes to the trust that is the hallmark of the client-lawyer relationship. The client is thereby encouraged to seek legal assistance and to communicate fully and frankly with the lawyer, even as to embarrassing or legally damaging subject matter. The lawyer needs this information to represent the client effectively, and if necessary, to advise the client to refrain from wrongful conduct. Almost without exception, clients come to lawyers in order to determine their rights and what is, in the complex of laws and regulations, deemed to be legal and correct. Based upon experience, lawyers know that almost all clients follow the advice given and the laws upheld. Thus, the client's informed consent must be taken in order for a member to reveal information that is relating to the representation. In the absence of the client's informed consent, a member must not reveal information relating to the representation. The attorney must also avoid conflicts of interest. The Model Rules of Professional Conduct, Rule 1.7, defines the conflict of interest with current clients and states that a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. A concurrent conflict of interest exists if the representation of one client will be directly adverse to another client, or there is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by a personal interest of the lawyer. Rule 1.8 in conflict of interest states that current clients have very specific rules. A lawyer shall not enter into a business transaction with a client or knowingly acquire an ownership, possessory, security, or other pecuniary interest adverse to the client interest unless the transaction and terms which the lawyer acquires are the interest that is fair and reasonable to the client and are fully disclosed and transmitted in writing in a manner that can be reasonably understood by the client. The client is advised in writing of the desirability of seeking and is given a reasonable opportunity to seek the advice of independent legal counsel on the transaction, and the client gives informed consent in a writing signed by the client to the essential terms of the transaction and the lawyer's role in the transaction, including whether the lawyer is representing the client in the transaction. A lawyer shall not make an agreement prospectively limiting the lawyer's liability to a client for malpractice unless the client is independently represented in making the agreement, or settle a claim or potential claim for such liability with an unrepresented client or former client unless that person is advised in writing of the desirability of seeking and is given a reasonable opportunity to seek the advice of independent legal counsel in connection therewith. A lawyer shall not acquire a proprietary interest in the cause of action or subject matter of litigation the lawyer is conducting for a client, except that the lawyer may acquire a lien authorized by law to secure the lawyer's fee or expenses and contract with a client for a reasonable contingency fee in a civil case. A lawyer shall not have sexual relations with a client unless a consensual sexual relationship existed between them when the client-lawyer relationship commenced. The California rules continue in Rule 3-300 in the avoidance of interests adverse to the client. A member shall not enter into a business transaction with a client or knowingly acquire an ownership, possessory, security, or other pecuniary interest adverse to the client, unless each of the following requirements has been satisfied. The transaction or acquisition and its terms are fair and reasonable to the client and are fully disclosed and transmitted in writing to the client in a manner which should reasonably have been understood by the client, and the client is advised in writing that the client may seek the advice of an independent lawyer of the client's choice and is given a reasonable opportunity to seek that advice, and the client thereafter consents in writing to the terms of the transaction or the terms of the acquisition. Rule 3-300 is intended to apply where the member wishes to obtain an interest in client's property in order to secure the amount of the member's past due or future fees. Which brings us to ending the client relationship. The model rules give us guidance from Rule 1.16, declining or terminating representation. A lawyer shall not represent a client, or where representation has commenced, shall withdraw from the representation of a client if the representation will result in violation of the rules of professional conduct or other law. Lawyer's physical or mental condition materially impairs the lawyer's ability to represent the client, or the lawyer is discharged by the client. A lawyer may withdraw from representing a client if withdrawal can be accomplished without material adverse effect on the interests of the client. The client persists in a course of action involving the lawyer's services that the lawyer reasonably believes is criminal or fraudulent. The client has used the lawyer's services to perpetuate a crime or fraud. The client insists upon taking action that the lawyer considers repugnant or with which the lawyer has a fundamental disagreement. The client fails substantially to fulfill an obligation to the lawyer regarding the lawyer's services and has been given reasonable warning that the lawyer will review and withdraw unless the obligation is fulfilled. The representation will result in an unreasonable financial burden on the lawyer or has been rendered unreasonably difficult by the client or other good cause for withdrawal exists. A lawyer must comply with applicable law requiring notice to a permission of a tribunal when terminating a representation. When ordered to do so by a tribunal, a lawyer shall continue representation notwithstanding good cause for terminating the representation, but upon termination of the representation, a lawyer shall take steps to the extent reasonably practicable to protect a client's interests, such as giving reasonable notice to the client, allowing time for employment of other counsel, surrendering papers and property to which the client is entitled, and refunding any advance payment of fee or expense that has not been earned or incurred. The lawyer may retain papers relating to the client to the extent permitted by other law. This brings us to obligations to third parties in the legal system. Counseling or assisting illegal or fraudulent conduct, the requirement of honesty in all communications, and the threats of criminal prosecution. The Model Rules of Professional Conduct, Rule 2.4, the lawyer serving as a third-party neutral. A lawyer serves as a third-party neutral when the lawyer assists two or more persons who are not clients of the lawyer to reach a resolution of a dispute or other matter that has arisen between them. Service as a third-party neutral may include service as an arbitrator, a mediator, or in such other capacity as will enable the lawyer to assist the parties to resolve the matter. A lawyer serving as a third-party neutral shall inform unrepresented parties that the lawyer is not representing them. When the lawyer knows or reasonably should know that a party does not understand the lawyer's role in the matter, the lawyer shall explain the difference between the lawyer's role as a third-party neutral and a lawyer's role as one who represents a client. In the California Rules of Professional Conduct, Rule 3-320, Relationship with Other Parties Lawyer, a member shall not represent a client in a matter in which another party's lawyer is a spouse, parent, child, or sibling of the matter, lives with the member, is a client of the member, or has an intimate personal relationship with the member, unless the member informs the client in writing of the relationship. All sorts of things can happen when we're talking about deals for money. Also, when we're looking at the criminal justice system and the policies that are at play in the taking of property, specifically when we're dealing with notions of civil forfeiture. Criminal forfeiture requires conviction. However, civil forfeiture merely requires accusation. Cash, real and personal property taken by police and prosecution throughout jurisdictions in the United States is becoming a very serious problem. The Institute for Justice reports as of 2012, in at least 26 states, over $200 million has been incurred by the states through civil forfeiture, though no crime has been charged. So how much is too much? Where does it go? Why is it that we seize these proceeds? Law enforcement will say that it's because we have drug trafficking, weapons trafficking, human trafficking, and therefore the civil forfeiture is required to take this ill-gotten gain from somebody who is accused of a crime. However, one need not attend law school to understand the burden of proof that must be established in order to determine criminal guilt. So if an attorney, whether employed by the government or retained by an accused, deals with a civil forfeiture statute, they must be cognizant of the implications of such statute. This leads us to another ethical dilemma that we're currently facing in the United States involving private prisons, or delegating post-conviction correctional duties of the state to private parties whose operations are publicly held for profit corporations, which also leads to a discussion on bail in this country. We know that there is no true right to bail, only the right against the imposition of excessive bail. With all of these implications that are specific to the criminal justice world, an attorney must understand those special obligations to lawyers in litigation, specifically the duty to reject actions brought merely to harass or injure, limitations on trial publicity, and the duty of honesty in disclosing perjury. The model rules gives us guidance through Rule 4.1, truthfulness in statements to others. In the course of representing a client, a lawyer shall not knowingly make a false statement of material fact or law to a third person, or fail to disclose a material fact when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client, unless disclosure is prohibited. California rules continue with Rule 5-100 in threatening criminal, administrative, or disciplinary charges, in that a member shall not threaten to present criminal, administrative, or disciplinary charges to obtain an advantage in a civil dispute. The business of practicing law, solicitation and advertising, regulation of specialization, and the division of fees. The model rules gives us guidance to advertising regulations pursuant to Rule 7.2, where a lawyer may advertise services through written, recorded, or electronic communication, including public media. A lawyer shall not give anything of value to a person for recommending the lawyer's services, except that a lawyer may pay the reasonable costs of advertisements or communications permitted by this rule, pay the usual charges of a legal service plan or a not-for-profit or qualified lawyer referral service. A qualified lawyer referral service is a lawyer referral service that has been approved by an appropriate regulatory authority, and pay for a law practice in accordance with Rule 1.17 and refer clients to another lawyer or a non-lawyer professional pursuant to an agreement not otherwise prohibited under these rules that provides for the other person to refer clients or customers to the lawyer if the reciprocal referral agreement is not exclusive and the client is informed of the existence and nature of the agreement. Any communication made pursuant to this rule shall include the name and official address of at least one lawyer or law firm responsible for its content. The California rules are similar in that Rule 1-400 gives us guidance in regard to advertising and other forms of solicitation. For purposes of this rule, communication means any message or offer made by or on behalf of a member concerning the availability for professional employment, or a member or a law firm directed to any former, present, or prospective client, including but not limited to the following: Any use of firm name, trade name, fictitious name, or other professional designation of such member or law firm, or any stationery, letterhead, business card, sign, brochure, or other comparable written material describing such member, law firm, or lawyers, or any advertisement, regardless of medium, of such member or law firm directed to the general public or any substantial portion thereof, or any unsolicited correspondence from a member or law firm directed to any person or entity. For purposes of this rule, a solicitation means any communication concerning the availability for professional employment of a member or a law firm in which a significant motive is pecuniary gain, and which is delivered in person or by telephone or directed by any means to a person known to the sender to be represented by counsel in a matter which is a subject of the communication. A solicitation shall not be made by or on behalf of a member or law firm to a prospective client with whom the member or law firm has no family or prior professional relationship, unless the solicitation is protected from abridgment by the Constitution of the United States or by the Constitution of the State of California. A solicitation to a former or present client in the discharge of a member's or law firm's professional duties is not prohibited. A communication or a solicitation as defined herein shall not contain any untrue statement, or contain any matter, or present or arrange any matter in a manner or format which is false, deceptive, or which tends to confuse, deceive, or mislead the public, or omit to state any fact necessary to make the statements made in the light of circumstances under which they are made not misleading to the public, or fail to indicate clearly, expressly, or by context that it is a communication or solicitation, as the case may be, or be transmitted in any matter which involves intrusion, coercion, duress, compulsion, intimidation, threats, or vexatious or harassing conduct. Trial publicity. The model rules of professional conduct give us guidance through Rule 3.6. A lawyer who is participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. A lawyer may state the claim, offense, or defense involved and accept, when prohibited by law, the identity of the persons involved, information contained in a public record, that an investigation of a matter is in progress, the scheduling or result of any step in litigation, a request for assistance in obtaining evidence and information necessary, a warning of danger concerning the behavior of a person involved when there is reason to believe that there exists the likelihood of substantial harm to an individual or to the public interest. And in a criminal case, in addition to what we've just discussed, the identity, residence, occupation, and family status of the accused. If the accused has not been apprehended, information necessary to aid in the apprehension of that person, the fact, time, and place of arrest, and the identity of investigating and arresting officers or agencies, and the length of the investigation. A lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from the substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. No lawyer associated in a firm or government agency with a lawyer shall make a statement prohibited by this rule. In California, a member who is participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that a reasonable person would expect to be disseminated by means of public communication if the member knows or reasonably should know that it will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. Rule 5-120 is intended to apply equally to prosecutors and criminal defense counsel. Whether an extrajudicial statement violates Rule 5-120 depends on many factors, including whether the extrajudicial statement presents information clearly inadmissible as evidence in the matter for the purpose of proving or disproving a material fact and issue, whether the extrajudicial statement presents information the member knows is false, deceptive, or the use of which would violate the Business and Professions Code, whether the extrajudicial statement violates a lawful gag order or protective order, statute, rule of court, or special rule of confidentiality, for example, in juvenile, domestic, mental disability, and certain criminal proceedings, and the timing of the statement. We have special rules that are specific to district attorneys and the issues surrounding the criminal trial. We have a formal disciplinary process which indicates personal financial liability and also contempt sanctions. Through discipline, we have training that holds, corrects, strengthens, and perfects the moral character of those parties who are charged with the duty of acting as officers of the court in their representation of clients and also the people of the jurisdiction. Through discipline, we have the Model Rules of Professional Conduct, Rule 8.5. A lawyer admitted to practice in this jurisdiction is subject to the disciplinary authority of this jurisdiction, regardless of where the lawyer's conduct occurs. A lawyer not admitted in this jurisdiction is also subject to the disciplinary authority of this jurisdiction if the lawyer provides or offers to provide any legal services in this jurisdiction. A lawyer may be subject to the disciplinary authority of both this jurisdiction and another jurisdiction for the same conduct. Choice of law. In any exercise of the disciplinary authority of this jurisdiction, the rules of professional conduct to be applied shall be as follows. For conduct in connection with a matter pending before a tribunal, the rules of the jurisdiction in which the tribunal sits, unless the rules of the tribunal provide otherwise. And for any other conduct, the rules of the jurisdiction in which the lawyer's conduct occurred, or if the predominant effect of the conduct is in a different jurisdiction, the rules of that jurisdiction shall be applied to the conduct. A lawyer shall not be subject to discipline if the lawyer's conduct conforms to the rules of a jurisdiction in which the lawyer reasonably believes the predominant effect of the lawyer's conduct will occur. In California, we have a unique system of alternative discipline, an alternative discipline program. The alternative discipline program addresses the substance abuse and mental health problems of attorneys against whom formal disciplinary proceedings have been initiated in the state bar court. Effective January 1st, 2002, pursuant to the Business and Professions Code, the State Bar Act, Section 6231, directs the Board of Governors of the State Bar of California to establish and administer an Attorney Diversion and Assistance Program. The Lawyers Assistance Program is called LAP, LAP. The State Bar has implemented the LAP, which primarily addresses the substance abuse and mental health problems of attorneys who are referred to LAP or who voluntarily seek to participate in LAP. The program offers support and structure to attorneys recovering from these disorders. The State Bar Court Alternative Discipline Program, the ADP, represents the first comprehensive program in the United States for addressing the identification, assessment, and treatment of substance abuse and mental health problems of respondents in the discipline process. The ADP is designed to protect the public, the schools, and the courts, as well as the legal profession, while respondents with substance abuse or mental health problems receive treatment. Further, the discipline will be revolved around sanctions. Sanctions can include either public or private reprimands, a temporary suspension of one's license to practice within that jurisdiction, or a permanent disbarment. The Cal Bar Journal routinely publishes those members who have been disbarred within the jurisdiction. In 2015, the California Rules of Court describe Rule 9.20, the duties of disbarred, resigned, or suspended attorneys. The Supreme Court may include in an order disbarring or suspending a member of the state bar or accepting his or her resignation a direction that the member must, within such time limits as the Supreme Court may prescribe, notify all clients being represented in pending matters and any co-counsel of his or her disbarment, suspension or resignation, and his or her consequent disqualification to act as an attorney after the effective date of the disbarment, suspension, or resignation. And in the absence of co-counsel, also notify the clients to seek legal advice elsewhere, calling attention to any urgency in seeking the substitution of another attorney or attorneys. Deliver to all clients being represented in pending matters any papers or other property to which the clients are entitled, or notify the clients and a co-counsel of a suitable time and place where the papers and other property may be obtained, calling attention to any urgency for obtaining the papers or other property. Refund any part of the fees paid for and have not been earned, and notify opposing counsel in pending litigation or, in the absence of counsel, the adverse parties of the disbarment, suspension, or resignation, and consequent disqualification to act as an attorney after the effective date of the disbarment, suspension, or resignation. And file a copy of the notice of the court, agency, or tribunal before which the litigation is pending for inclusion in the respective file or files. Notices to clients, co-counsel, opposing counsel, and adverse parties. All notices required by an order of the Supreme Court or the State Bar Court under this rule must be given by registered or certified mail, return receipt requested, and must contain an address where communications may be directed to the disbarred, suspended, or resigned member. Filing proof of compliance. Within such time as the order may prescribe after the effective date of the member's disbarment, suspension, or resignation, the member must file with the clerk of the State Bar Court an affidavit showing that he or she has fully complied with those provisions of the order entered under this rule. The affidavit must also specify an address where communications may be directed to the disbarred, suspended, or resigned member. Sanctions for failure to comply. A disbarred or resigned member's willful failure to comply with the provisions of this rule is a ground for denying his or her application for reinstatement or readmission. A suspended member's willful failure to comply with the provisions of this rule cause for disbarment or suspension and for revocation of any pending probation. Additionally, such failure may be punished as a contempt or a crime. The Washington State Legislature provides the following grounds of disbarment or suspension. An attorney or counselor may be disbarred or suspended for any of the following causes arising after his or her admission to practice. His or her conviction of a felony or misdemeanor involving moral turpitude, in which case the record of conviction shall be conclusive evidence. Willful disobedience or violation of an order of the court requiring him or her to do or forbear an act connected with or in the course of his or her profession, which he or she ought in good faith to do or forbear. Violation of his or her oath as an attorney or his or her duties as an attorney and counselor. Corruptly or willfully and without authority appearing as attorney for a party to an action or proceeding. Lending his or her name to be used as attorney and counselor by another person who is not an attorney and counselor. For the commission of any act involving moral turpitude, dishonesty, or corruption, whether the same be committed in the course of his or her relations as an attorney or counselor at law or otherwise, and whether the same constitute a felony or misdemeanor or not, and if the act constitute a felony or misdemeanor, conviction thereof in a criminal proceeding shall not be a condition precedent to disbarment or suspension from practice therefore. Misrepresentation or concealment of a material fact made in his or her application for admission or in support thereof. Disbarment by a foreign court of competent jurisdiction. Practicing law with or in cooperation with a disbarred or suspended attorney, or maintaining an office for the practice of law in a room or office occupied or used in whole or in part by a disbarred or suspended attorney, or permitting a disbarred or suspending attorney to use his or her name for the practice of law, or practicing law for or on behalf of a disbarred or suspended attorney, or practicing law under any arrangement or understanding for fees or compensation of any kind with a disbarred or suspended attorney or with any person not licensed to practice. Gross incompetency in the practice of the profession. Also, violation of the ethics of the profession. Lastly, we would like to emphasize the personal liability and then also the liability of those who are concerned with the matter, the vicarious liability of partners in a firm, partners in a law practice. Lastly, the lack of resources and the responsibilities of judges, disqualification and recusal, the extrajudicial money-making, and political activity and appearance of impropriety are key to understanding the ethical constraints of those who operate the criminal justice system. The model rules of professional conduct, specifically Rule 3.8, Special Responsibilities of a Prosecutor, states that the prosecutor in a criminal case shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. Also make reasonable efforts to assure that the accused has been advised of the right to and the procedure for obtaining counsel and has been given reasonable opportunity to obtain counsel. Not seek to obtain from an unrepresented accused a waiver of important pretrial rights, such as the right to a preliminary hearing. Make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense, and in connection with sentencing, disclose to the defense and to the tribunal all unprivileged mitigating information known to the prosecutor, except when the prosecutor is relieved of this responsibility by a protective order of the tribunal. Not subpoena a lawyer in a grand jury or other criminal proceeding to present evidence about a past or present client unless the prosecutor reasonably believes the information sought is not protected from disclosure by any applicable privilege. The evidence sought is essential to the successful completion of an ongoing investigation or prosecution, and there is no other feasible alternative to obtain the information, except for statements that are necessary to inform the public of the nature and extent of the prosecutor's action and that serve a legitimate law enforcement purpose. Refrain from making extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused, and exercise reasonable care to prevent investigators, law enforcement personnel, employees, or other persons assisting or associated with the prosecutor in a criminal case from making an extrajudicial statement that the prosecutor would be prohibited from making. In California, we have trial conduct regulated through Rule 5-200. In presenting a matter to a tribunal, a member shall employ for the purpose of maintaining the causes confided to the member such means only as are consistent with truth, shall not seek to mislead the judge, judicial officer, or jury by an artifice or false statement of fact or law, shall not intentionally misquote to a tribunal the language of a book, statute, or decision, shall not, knowing its invalidity, cite as authority a decision that has been overruled or a statute that has been repealed or declared unconstitutional, and shall not assert personal knowledge of the facts at issue except when testifying as a witness. The duties of the prosecution also includes appointed counsel, because there is duty to the appointed counsel with the understanding that appointed counsel truly is not free and that the client will ultimately have to pay for the services of appointed counsel. Further, in most jurisdictions, the public defender is not free and it always requires a minimum payment. Model Rules of Professional Conduct, Rule 8.2, controls judicial and legal officials. in that a lawyer shall not make a statement that the lawyer knows to be false or with reckless disregard as to its truth or falsity concerning the qualifications or integrity of a judge, adjudicatory officer, or public legal officer, or of a candidate for election or appointment to judicial or legal office. A lawyer who is a candidate for judicial office shall comply with the applicable provisions of the Code of Judicial Conduct. The California Rules of Professional Conduct, Rule 1-700. A member who is a candidate for judicial office in California shall comply with Canon 5 of the Code of Judicial Ethics. For purposes of this rule, candidate for judicial office means a member seeking judicial office by election. The determination of when a member is a candidate for judicial office is defined by the terminology section of the California Code of Judicial Ethics. The California Code of Judicial Ethics is available online and can always be found at www.courtinfo.ca.gov. In conclusion, we have to maintain the access to justice, the access to the justice system. And the only way to provide justice is by competent attorneys, competent members of the legal profession. And that competency can only be accrued through training and perfected through training, and then checked through the codes of conduct, the professional rules, depending upon the jurisdiction. The ABA has codified them, as has every jurisdiction within the United States. We must adhere to the codification of these rules in order to imply ethics, because it is the ethics and the competence that will ultimately bring access to justice. And with that, I would like to leave you today. Thank you very much for your time.